Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-1016, Levine Schwab Partnership, doing business as Schwab Multimedia LLC, appellant, versus Federal Communications Commission. Mr. Adamchak for the appellant, Ms. May for the appellee.
Good morning, Your Honors. May it please the court. My name is Keenan Adamchak, and I represent the appellate, Levine Schwab Partnership, doing business as Schwab Multimedia LLC. Your Honors, I'd like to reserve 3 minutes for rebuttal. My client is before the court today because the FCC acted arbitrarily and capriciously in denying Schwab's tolling extension request for its AM broadcast station's construction permit at the height of the COVID-19 pandemic. Justice and equity require that the FCC's order be vacated, the denial of tolling be reversed, and the station's construction permit and its pending modification applications be reinstated. This court must find in favor of the appellate for 3 reasons. First, the FCC failed to provide Schwab fair notice of its departure from its liberal tolling standards established in the third toll. These liberal tolling standards created a legitimate reliance interest for Schwab, which reasonably followed in its fourth tolling request. Second, in denying Schwab's tolling request, the FCC failed to provide an explanation for the application of its disparate tolling treatments to Schwab, both internally between Schwab's tolling requests and externally with those of other similarly situated broadcasters. This court has long held that such agency actions are arbitrary and capricious and undermine the integrity of the administrative process. Finally, the FCC blindsided Schwab by denying tolling based on the contrary and unargued basis of site loss. Nevertheless, the FCC permits tolling to be granted for site losses beyond a permittee's control under the agency's waiver standard. The unilateral actions of Schwab's landlord in revoking its site access by the diplexing issues were being resolved beyond Schwab's control. Schwab's arguments that its site loss serves as a valid toll and waiver basis are judiciable because the FCC first determined sua sponte that site loss was the proximate cause of Schwab's construction delays and simultaneously denied Schwab the opportunity to refute that finding by raising the issue in a final FCC order. As for my first point, fairness required that the FCC provide Schwab with exacting tolling standards for the fourth tolling request. As both the FCC and this court have observed.
Can you address standing, please?
Yes, Your Honor. Schwab has standing before this court because the denial of Schwab's tolling request and the subsequent expiration of its construction permit is redressable by a favorable decision because it would return Schwab to an opportunity to construct the station.
What if, for standing purposes, we have to assume that there's merit in your arbitrary and capricious arguments just for the sake of resolving standing, but I'm not sure that we have to ignore the site loss issue when we assess standing, do we?
No, Your Honor. We don't have to worry about the site loss issue because the restoration of the construction permit, the redressability by nearly restoring the construction permit, restores an opportunity to construct. Construction permits are malleable and they can be modified up until time of the expiration date by moving to other sites. So just because Schwab can't build at the first site, it can, if it's a minor modification application to restore, so long as those applications are granted up until the time of the expiration date, they can move to another site and build there. On remand, we must, the FCC cannot use their discretion to deny grant of those minor modification applications, as the court previously found in NTCH.
Is your first application to transfer still pending for the FCC? So when they granted, then ungranted, and put into pending status?
All those applications have been now dismissed, Your Honor, as a result of the forced tolling orders.
So even the one that was pending has also been dismissed?
All of them have been dismissed.
Okay, so you don't have anything pending before the FCC, right?
Nothing, Your Honor, because the underlying construction permit had expired. The pending modification applications followed that. They had to be dismissed as well. So we're asking, Your Honor, for reinstatement of those minor modification applications to pending status as a result of the restoration of the construction
I want to follow up on Judge Wilkins' question. Imagine that we rule in your favor, and imagine that everything that possibly go right for you in terms of getting this station built goes right. Walk me through how that would happen, and let me know when the thing that's happening is certain to happen, or it's just something that you hope.
Yes, Your Honor. So,
and maybe start by how long you would need to get it done in.
you would need, and we request the restoration to the status quo, which would be 6 months and 22 days on
Okay.
the permit. Schwab would require the second modification application to be granted, as it demonstrated in its petition for reconsideration.
And we
has-
could not, I know I'm interrupting you, but I'm going to let you finish. I just want to make sure I understand. We can't grant that second modification to you today.
Understood. No,
Right.
it would have to be granted on.
Okay, please carry on.
Yeah, remand. Assuming that the construction permit is reinstated, the tolling order is vacated and reversed, we're asking Schwab be returned to a position where it had 6 months and 22 days struck. And on remand, we would request expedited treatment of the second modification application where Schwab has authority to build. Schwab, as demonstrated in the petition for recon, provided a copy of a site lease at that site. Schwab is ready, willing, and able to build at that site as soon as that permit is granted.
And I don't want to interrupt you. Was that the end?
Yeah.
Okay, so then the second modification, that would be a modification that allows you to build at a site that's different than the original site, correct?
Correct.
And have you a guarantee from the owner of that site that you can build?
Yes.
And you think you could get this built in 6 months and 22 days?
Yes. It's a very small tower. It's about 50 feet high. They can get it at that. It would 6 months and 22 days is plenty of time to get all that done.
What evidence in the record is there of that?
In the petition for recon, there is a site lease that is triggered upon FCC approval of the second modification. And once that goes forward, they will be able to build. They will still need to acquire a tower equipment, but they are ready to go. As the record also shows, they've acquired for equipment with manufacturers, and as soon as they've been working in the past couple of months, as soon as they get that granted, they build it hit the ground. But the site lease is in the record.
If it took the FCC, let's say, 6 months and 12 days to grant the second modification, would that leave you 10 days to build the tower?
Yes, it would. And
How quickly does the FCC usually move on something like a second modification request?
the FCC, it varies. If you request expedited treatment, I've seen applications granted within a month, within weeks. If you don't, it could take months. On remand, Schwab would request expedited treatment and push the FCC to get
just to give you a chance to kind of rebut whatever answer the government, whatever worst case scenario the government might give when I ask them this question. I'm going to ask them, what are the reasons why that second modification request might be denied? And would you come back and say, oh, there are no plausible reasons that that second modification would be denied?
As far as I know, Your Honor, there are no reasons why that application would be denied the second mod. I know there was issues with the first mod, but I can go back and review and file a 28-J letter to explain and look closer at that issue.
Has anyone filed objections to that one?
To the second modification application, I do not believe, Your Honor, only to the first one.
And just to clarify, I thought sometimes time periods were told during the pendency of administrative proceedings. So would your 6 months be told while you're waiting for the FCC to act on the expedited motion for site approval or not?
I believe so, Your Honor, under 28B2, 3598B2, it can be told for administrative delays resulting from challenges to the CP.
Challenges to the CP, so I'm not recalling what the CP is.
I'm sorry, the construction permit.
Okay.
Your Honor. I believe
But
that,
we don't know about challenges, we don't know about delays while you're waiting for a site transfer motion to be approved.
no, not for delays for a site transfer.
Okay.
It would have to be a challenge directly to the construction.
Presumably, if you were to prevail, the FCC wouldn't
Yes.
drag its feet to deliberately sabotage your efforts. That would be
Correct,
quite untoward by the government.
Yeah. So as with regards to fair notice, fairness required the FCC provide Schwab with exacted standards for the fourth tolling request. As both the FCC and the court have observed, sudden departure from prior standards creates a reliance concern warranting notice. Schwab reasonably understood the third tolling order to require that it merely file a status report requesting continued tolling treatment due to the pandemic. As for my second point, under the melody music standard, the FCC may not treat similarly situated parties differently without adequate explanation. The FCC applied different tolling standards to Schwab in the fourth tolling request and to either the second or third tolling request. Not only was the FCC internally consistent, the FCC also applied different standards to Schwab than to its tolling requests of similarly situated broadcasters, wherein the FCC found that COVID was the reason for the construction delays, and the landlord's denial of site access was a legitimate tolling basis. As for my final point, site loss, the FCC blindsided Schwab by denying tolling for site loss. Contrary to the FCC's arguments, the FCC has always considered waivers construction deadlines based on site loss on a case-by-case basis under the general waiver standard. Here, the FCC failed to provide Schwab with the requisite hard look at Schwab's case by examining whether its landlord's actions were outside of Schwab's control.
What did you do to establish a good cause for the waiver that you, if your request for tolling were to be construed as a waiver, what did in your fourth application, what did you demonstrate there to establish good cause?
In the fourth tolling request, we to demonstrate good cause, we demonstrated that grant of the waiver would give us more time to construct in light of the ongoing delays. That was a good cause. The idea was that AM broadcast stations already have a hard time getting themselves built. It's just the basic nature of their technology. You have to use a whole tower to radiate the signal. And so site choice is basically, as the FCC observed in their AM revitalization plan, AM broadcast stations have a lot of trouble, and that type of transmission is going away. So good cause would give Schwab enough time in face of all these circumstances beyond its control that are preventing its ability, despite its diligent efforts to get constructed, more time to get constructed. So that would be the good cause.
When you were trying to show, I guess, on the reconsideration of the fourth tolling request, that COVID was the reason you couldn't get anything built, I would have thought one way to show that was just email a contractor and say, I want you to build a radio tower at this address. And then the contractor might reply back, I'm too full because there's a COVID backlog, or I can't do it because I don't have workers willing to work during the pandemic, or there's a lockdown, whatever the answer is. But I think you didn't do that because you can't ask a contractor to build on a site where you don't have permission to build. Is that why?
Your Honor, I do not know why they did not ask demonstrate any evidence of communicating with tower crews as to why they whether or not they could build at a site, whether or not they had authority to build at a site. My understanding is they were in communication with various tower crews, but for whatever reason, that evidence wasn't presented in the record. I do not know how to answer the question of as whether or not they could build at a specific site, whether or not they have authority.
Well, there was no site where they had permission to build during the period of time in question, correct?
They still had at least at the original site.
But they didn't have permission to build at the original site.
They did not. They were trying to work out a technical issue to gain the, yeah.
Okay, but did they have permission to build on the original site during, say, 2020?
No, Your Honor. So as to the hard look standard,
Were they still trying to sort out is there any evidence in the record that they were doing something to address the diplexing issue in 2020 or 2021 at the original site, or had that been abandoned as well?
the only evidence in the record of them continuing to work for the diplexing site was in each minor modification applications. They addressed the fact that there were issues at the site that hopefully they could go back and resolve. They also went back and addressed these in their pleadings in the petition for reconsideration.
Did they ever explain what they were doing to try to resolve them, other than they hoped to resolve them?
I do not know, Your Honor. From what I understand, they were still in negotiations with the landlord and the other broadcast stations that were also using that site to resolve the issue. Do not know the specifics, but I could get back to you on that in 28
Well, no, it's just that to obtain tolling for an extension of tolling under the so-called Act of God provision, you're supposed to show steps that were proposed to be taken to resolve impediments that haven't taken or you propose to take to resolve impediments to construction.
Are you referring to 733598D, Your Honor?
I don't have the numbers memorized.
Okay.
I just know that the regulation where it says if you get an initial extension under Act of God, and then if you want to extend it further, you have to make a more particularized showing of three things. And the third prong is that you have to show what steps you've taken or proposed to take to address the asserted impediments to construction.
Yes, Your Honor. That rule, Schwab recently believed that rule was not applicable to them for the fourth tolling request, because in the third tolling request, it just merely asked for a status report of the continued treatment. And given the fact that the third tolling order granted the third tolling request based on, as the FCC put it, generalized grievances, we believe they were under a liberal tolling standard, so that 3598 didn't apply.
Yeah, if the grant of the third tolling request said if construction cannot resume within 6 months. So first of all, I guess you had to show that construction was not able to resume within those 6 months. And when they say a status report requesting continued tolling treatment, there's nothing in there that says we're not applying the regulations that require a particular showing for an extension. It doesn't say we're suspending our usual requirements. You just have to mail something in and ask for an extension. There's nothing in that third tolling grant of the third tolling request that says our ordinary standards aren't going to apply.
Yes, Your Honor, but at the same time, the third tolling request was granted under liberal standards, as the FCC admitted in the order. So
sure, that didn't mean, but they never said we're going to keep these liberal standards going, did they? Where did they say how long we're going to keep these liberal standards going?
They did not.
Okay. And then the letter that you rely upon doesn't say anything about not applying existing regulations. And it's prefaced with if construction couldn't begin in the previous 6 months, which suggests a showing, then the status report, there's no reason to read status report as inconsistent with complying with the regulation. I'm trying to understand why your client thought all it had to do was request another extension and not make the regulatorily required showing.
Because, as I said, it understood the order to not require a heightened standard because it was granted based on generalized grievances. And notwithstanding the fact that the order also said they needed to show that construction did not complete, they read that the second that sentence of status report continued treatment as just saying that, because as the FCC said in other cases, they'll either cite 7398D or they'll lay out what you actually need to do in your next steps for other broadcasters that were granted tolling during COVID. So as Schwab saw it was, we just need to request a status update. Yeah, construction did not occur. We got to remember things are still in flux in September 2020. There were no vaccines. people were the vast majority of people were working from home. The sport was still remote. So in this time of uncertainty, they felt that the FCC would continue to apply their liberal tolling standards going forward.
Okay, thank you. Very much. We'll give you a couple minutes for rebuttal.
Thank you.
Good morning, Your Honors, and may it please the court. I'm Rachel Proctor-May for the FCC, and I'll start with standing. As Your Honors noted, the opportunity presented by a permit doesn't have value if you can't take advantage of that opportunity. And there's nothing in the record that shows that it's more than speculative that Schwab could take advantage of that opportunity. There's the 3 sites that have been identified. The first 2 failed for technical reasons, and there is nothing in the record that suggests that those technical reasons have ever been resolved. The 3rd site, which Schwab put in the application for with its petition for reconsideration, has never gone through FCC approval, not for an exercise of policymaking discretion, but for technical compliance with the various requirements that are applicable. The application is in the JA at 227, and it'll give you a sense of the kinds of things that the commission is going to review the application. Schwab's counsel represented that the owner has guaranteed that construction can happen upon FCC approval. What the record shows is that the lease, this is JA 160, the lease has not been executed. It's signed by Schwab, but not the lessor. And it says that the agreement is void until the approvals, but it doesn't specifically say that there is a trigger provision or show that the...
You're talking about the first original site? Or the
no, this
third?
is for,
Now
this
you're
is
on
for the 2020 site. So the one where the that it put in an application.
This is the site that if they were to get you to grant the second modification, they would possibly be able to build on the site. And you're
Correct.
saying
It's that
they
site.
haven't even gotten a signed lease for that site.
According to this record, it is not clear that they have executed a lease or will get the
How
lease for
fast
that
does
site.
the FCC usually decide a second modification request for expedited decision making? Something like this second modification.
It can happen very quickly. I have been told by the Bureau that they would not hold the time that they'd be reviewing this against the permit deed.
So they would, so that if they get this second modification granted, let's say in 7 months, they'll still have 6 months and 22 days.
That is my understanding.
Okay. And what are some reasons to deny that second modification? Not that specific one, but just in general, why does something like that get denied?
A lot of times it has to do with transmission issues. So, for example, there was a ground conductivity issue that hung up the second application. That just means, as I understand it, the radio frequency emissions are interfering with other transmissions that need to occur.
I think it was probably their burden, not yours, their burden to show that it's likely the second modification request will be granted, which would then make an order by us able to redress their injury. But from your perspective, how likely is it in the run-of-the-mill modification request for a new site?
I cannot answer that question because we haven't reviewed its application.
Not
There
the
might be
specific, I'm
some-
just saying, like,
Sure,
do they get granted 99% of the time, 1% of the time, 50-50?
I do not know the statistic on that. Again, it's their burden. I would say that it is not completely unusual for site issues for sites to run into issues getting approved. So, for example, in addition to the issues with the second modification here, the WMLB case that is cited, that also ran into issues with their first approved site getting.
And if we think of their original site as site number 1, and then we think of the next place they tried to get permission as site number 2, they struck out on site number 2, right? Because it turned out that got granted and then denied.
Correct. Yeah, that was the ground conductivity issue. Schwab also suggests that it might be able to sell the permit. But again, there's nothing in the record as to whether there's any market value for a AM radio construction permit that is about to expire. So we would contend that's also speculative.
Isn't there, I thought that there was a case that was cited in the papers of an example of an AM construction permit being sold, or at least being marketable.
Oh, yes, construction permits can be marketable. But again, it's Schwab's burden to demonstrate a likelihood of redress. And here, again, where the permit is about to expire, where Schwab has been unable to get this over the finish line since 2016, it remains speculative whether this construction permit is marketable, particularly in Los Angeles, where there's well-documented issues with getting AM radio stations going. So turning to the merits, I'll start with the showing of the pandemic-based delay. As you noted,
can I just, or maybe it's related. How often do companies get to the level of fourth tolling requests?
I also don't know that.
Don't know that.
No.
Okay, I just didn't know if it was
I do
common,
know.
like
Yeah.
briefing extensions, they just keep coming
Sure.
in, or
The purpose of the commission's framework is to avoid the issue of sequential tolling requests. The streamlining orders in 1998 and 1999 were trying to solve the problem of endless iterative requests for extensions. And so that's why they put together this system of strict criteria under which automatic tolling is required, and then require a showing of exceptional circumstances beyond a permittee's control to get a waiver. And as Schwab admits, the site loss can only be considered under that waiver standard. So I'm going to transition to the site loss since we're on that. Schwab's main argument is that the landlord's actions were outside of the permittee's control, but that's not what the commission looks at in assessing whether the construction delay was outside of the permittee's control. The commission looks to factors such as timing and the permittee's diligence, because if you haven't done everything in your control to resolve the impediment, you can't say that the construction delay was outside of your control. This is discussed in the church planters' opinion in the brief.
One of your main arguments was that they hadn't raised waiver before the commission.
Waiver based on site loss, yes, Your Honor.
But it's, they certainly were arguing about tolling. And it's rather confusing because the commission itself sort of uses both terms, waiver and tolling, interchangeably.
Yeah.
Would warrant the tolling of construction time, entertain requests for waiver of our strict tolling provisions, tolling through waiver. And so it seems to me a bit much then to pin a lot of weight on the fact that they use the word tolling rather than waiver, because waiver just seems to be sort of this formalistic way of asking for tolling. Now, substantively a different showing, you can argue about that, but it does seem to me that the action needs to be not whether they ask for waiver or tolling, given the interchangeability of those terms in the commission's own words, but whether they met the waiver standards. Is that right? So it's hard to say they didn't argue it when they were talking about tolling.
Yes.
And so the question really is whether they met the standards for a site loss or tolling.
Right. 2 points on that. Schwab did not seek an extension based on site loss at all. It didn't seek tolling, it didn't seek waiver for its site loss. And so the the site loss only came up as one of the reasons that the commission concluded that it had not shown that the pandemic was the cause of the delay, because it found that it didn't have a site to build on. And so it's not a formalistic distinction to say that Schwab simply didn't raise site loss, and so there was nothing in the record to speak to whether there was a rare and exceptional circumstance beyond its control. And then just to get to the interchange of the sometimes confusing use of tolling and waiver, it is true that when you waive the tolling rules, the result is that the deadline is tolled, and that some of the use of language is not as clear as it could be. However, they still are two separate rules, and in the context of this order, it was very clear in discussing the site loss that the commission was only considering tolling under the rules, rule-based tolling. And that's because the commission recognized the possibility of waiver as distinct from tolling under the rules. That's in footnote 6 and also in footnote 51, using both terms, tolling and waiver. And so in discussing the site loss, it only addressed tolling. In addition, the application for review was only challenging the denial of tolling. And so it's hard to say that that statement was a decision on when a waiver might be applicable, because a waiver just simply wasn't at issue. So returning to the
Is the FCC planning to re-auction this?
I'm sorry.
Is the FCC planning to re-auction this?
The FCC has not made plans about whether it will or will not re-auction it. However, even if it doesn't re-auction it, the spectrum could still be put to use. For example, another AM license holder could file a modification application to enable it to use the spectrum to expand its audience. So returning to the issue of whether Schwab showed that the pandemic had interfered with its construction, obviously Schwab was on notice of the commission's standard for extensions of waiver requests. And Schwab's argument is simply that the commission should have applied a more lenient standard. As you observed, Your Honor, the Bureau never said it was waiving the rules. It said status report, which on its face implies basically what the rules require. And then as to the third tolling request, there was no...
Does it? Was I right or was I wrong? I mean, a status report doesn't sound like an application for extension of tolling under the regulations. Status report sounds like, hey, just let us know how things are going. Because it's a COVID pandemic, and yeah, things are still quite locked down and unsettled in September of 2020.
It still implies more than a bare notification. And so then the reasonable thing to do would be to look to the published rules and follow those requirements, because they
did everybody else get that? Did everyone? Did other companies get that? That got initial March, April, spring of 2020 extensions based on the pandemic. Did everyone else? I mean, I assume this was like a standardized letter that was issued for extensions at the time.
So at that time, March 2020,
in spring,
as we all recall, the world screeched to a halt. And so, yes,
I'm assuming this was kind of standardized language that was used, is all I'm asking. There's nothing.
I do not know if the language was standardized. I understand from the Bureau that people were panicking and putting in requests for tolling or waiver in various forms, and the Bureau was granting them immediately because of the urgency of the situation. But there's
no reason that you'd use specialized language for.
Correct.
So we can assume this is standard. I'm just curious because it is curious language. It doesn't say, make a submission subject to. I'm sorry, he cited the number, whatever the long number for the regulation is in the subsection on second rounds for active GOT extensions.
Sure, but I think the natural read is not that if the commission does not say the rule applies, you can assume it doesn't apply. It's that if the rule, if the commission doesn't say it's waived, you should assume that it does apply. And so that's one of the reasons why Schwab couldn't draw any inferences just from the term status report. The other reason is that in its fourth tolling request, the one that it filed in September 2020, it cited the commission's, it was the Bureau's public notice regarding waivers for COVID-based issues. And in that, the Bureau made very clear that anyone seeking an extension based on COVID needed to make a specific individualized showing of the effects of the pandemic on the permittee. So there was no reason for Schwab to have looked back to the third tolling.
If they had had a site to build on in September 2020, if Schwab had a site that they could begin building on immediately in September 2020, and they asked for tolling on the grounds that there's a pandemic and so they can't get built in time, I wouldn't think that they would have to demonstrate very much, because you could just turn on the news or open a newspaper. And I mean, there were states that were pretty open in September 2020, but California was not one of those states. And so to me, everything just keeps coming back to the site loss problem. They couldn't build in September 2020, pandemic or no pandemic, because they had no place to build. But if they had a place to build, why am I wrong that they couldn't have just told the FCC, California is in the middle of a pandemic and they've made it really hard for a lot of people to do a lot of things. Perhaps for very good policy reasons, they've made it really hard for a lot of people to do a lot of things.
That would require a waiver of the commission's rules. It would so that's why they couldn't do it. I mean, if they had asked for a waiver, they could have potentially asked for one. But it's showing, what's wrong with the showing that it made is that it, when it had the opportunity to put in its showing of how the pandemic had affected it, it didn't show that the pandemic had actually interfered with being able to get crews to the site.
I get that.
And the reason is,
I get that they didn't make concrete showings, and I get that they may have not used the word waiver or mislabeled this bureaucratic requirement versus that bureaucratic requirement. But just kind of from a big picture, if we're just trying to figure out, should this type of thing be granted by the FCC, not granted by the FCC? It seems like in September 2020, the prospect that COVID made it difficult, if not impossible, to build the kinds of things on the timelines that they used to be built was res ipsa.
I think a helpful thing would be to compare Schwab's showing to the kinds of showings that other permittees made. It is possible to show.
But why wasn't res ipsa good enough?
Because of the reasons that this framework is in place. The commission was trying to prevent this endless seeking of extensions of time. And so when it put together that framework, it recognized that there may be, in the case of acts of God, there may be disasters, but that you don't get to just keep saying, hey, I suffered a disaster until forever. You have to make a specific showing of how the disaster continues to affect you.
Don't you think in the context of California in September 2020 that disaster was ongoing?
It was the pandemic was obviously still continuing. However, and also just before I go too deep into this, obviously site loss is a completely sufficient
I think I'm with you on site loss.
Yeah, site loss is a completely sufficient basis to affirm. But on the pandemic, the Bureau gets into more of this than the Commission did, but there were plenty of businesses that were available to work. The filings that Schwab put in that list the different COVID restrictions demonstrate that there were businesses that were able to operate. Radio stations was one of the essential services, and also construction in support of that. So I think the commission was not required to assume that Schwab could build just because of the pandemic.
Thank you very much.
Thank you.
Okay, Mr. Adamchak, we'll give you 2 minutes.
The first point I want to address is redressability. As the court observed at Competitive Enterprise Institute versus National Highway Traffic Safety Association, party need not prove grant of the requested relief certain to redress the injury. And the court must also assume success on the merits and that the FCC would not use its discretion to deny grant of the application. So the fact that the FCC is saying that we can't, it's too speculative because we do not have a current site to build, that we cannot be successful on the merits based on the, that the relief requested won't redress our injury. Our injury was being deprived of the ability to construct our station. We are requesting by the vacator of the order, the restoration of the construction permit. That will restore Schwab's deprived right to opportunity to construct. And as I said earlier, the construction permit only conveys a right to construct. It can be modified, it could be sold, and on appeal, on remand, we have to assume the merits, minor mod, grant, been able to build, or the station being sold, and those applications being granted by the FCC. As for my second point, as for deference, the FCC acted unreasonably here and should not be accorded deference as to the terminology and the intent of what the steps Schwab needed to take next in the third tolling. As we alluded to earlier, there was a lot of uncertainty going on at the time between March and September 2020 as to what the future held with the pandemic. The FCC, in that uncertainty, the confusion on the ground, clearly the FCC needed to lay out guideposts for what Schwab needed to do next. Translator notice did not.
It kind of feels like fighting about what particular showing needed to be made. It's not like debating where to put the chairs on the deck of the Titanic, when really the problem is you were asking for an extension, and way more than 3 years, you didn't have a place to build at the time you applied for the fourth extension.
Yes, Your Honor, that's true.
And that's the basis for their decision.
Yes.
Why should we give you more time? You still don't have a place to build.
Because as the FCC alluded to way back in the streamlining orders, we will grant extensions as in a case-by-case basis for circumstances beyond a permittee's control.
Did the pandemic make acquisition of a new site beyond your control? I don't think so, because you talked about you were working on the site, the mall site, the second site. So
correct.
The pandemic wasn't interfering with your ability to acquire a second site.
It was interfering with our ability to move forward to put things into place to actually build the site.
But first you had to show the FCC you had a site, and you didn't do that in your motion.
We need to show that we had a site. Okay. We only needed to show following a third tolling request that the pandemic continued to delay construction.
All right. Great. Thank you.
Thank you, Your Honors.
Thank you very much. The case is submitted.
Case number 22-5047. Roger Severino, appellant, versus Joseph R. Biden Jr. in his official capacity as President of the United States et al. Mr. Mills for the appellant, Mr. Jett for the appellate.
Thank you, and may it please the court. Congress created an independent administrative conference and gave its council members terms to protect its role as a neutral advisor to Congress and all branches of government. In doing so, Congress acted in accord with the long American understanding of such terms as precluding at-will removal during the term. That's the point of the council's terms. The government's reading that a term of office does nothing to protect the office holder from removal, deprives the terms of all effect, would eviscerate the intellectual independence that OLC said is inconsistent with presidential removal power, and is the same reading rejected just a few years before the statute's enactment by the Supreme Court in Weiner. If this court were to adopt the government's reading, it would end the independence of this office and many offices protected by equivalent term provisions that have always been understood to prevent at-will removal, including by the Supreme Court and Free Enterprise Fund, SEC, chair of the Federal Reserve.
Mr. Mills, let's start with what labels apply to Mr. Severino and the ACUS. First, was he an executive officer?
The administrative conference is within the executive branch. It's an independent agency within the executive branch.
And so the executive branch, as I understand it, has principal officers, inferior officers, and employees. What was he?
Your Honor, I don't know that the characterization under the Appointments Clause really matters here. I think it's likely that he would just be considered an employee. Under Lucia, I don't think he had significant authority to be sure that.
And then and I know you don't think he was removable at will. Do you think he was removable for cause?
Your Honor, we don't have a position on that.
It's hard to kind of stick with that. I mean, it's hard for me to go with you. You want us to interpret the statute, and then we interpret the statute one way. You want us to decide its constitutionality. But you don't have a theory for how to interpret the statute if you don't have an answer to, was he removable for cause?
Well, Your Honor, our complaint alleges, which must be assumed true here, that he was removed for no reason. And so all we have to show is statute imposes some removal restriction.
Assume I will be unable to understand the meaning of this statute unless I can answer for myself the question, was Severino removable for cause? Then what would you answer?
Your Honor, again, I don't think we need to take a position one way or the other on that. I think Judge Silberman and Swan said it is likely that a appointee with a term appointment has protection equivalent to that of someone protected by a for-cause provision. So, and we said.
Okay, you don't take a firm position on whether Judge Silberman was right. You have not identified any case in which a term of office provision alone sufficed to limit presidential removal. Is that statement correct?
I don't think that's entirely correct, Your Honor. I think both Weiner and Humphrey's executor qualify.
Assume I've read those as closely as I can, and I don't think that it was the term of office provision alone that sufficed to limit presidential removal there. Do you have another case?
Sure. I'll just go through a couple, and I acknowledge that I'm not going to be able to give you an exact quote that you're looking for. But Swan at 987 says it is beyond dispute that Congress generally may place restrictions such as term limits on the president's removal.
They specifically reserved the question, did not answer the question of whether he could be removed during the term, and it was just a question of afterwards.
That's true, Your Honor, but they did not say the opposite.
One more case, and then I got another question.
Sure. So Free Enterprise Fund. There, the Supreme Court premised its constitutional holding that dual-layer removal restrictions are invalid on the fact that SEC commissioners are not removable at will.
Wouldn't the remedy in Free Enterprise Fund have been to not only refuse to apply the removal provision, but also to refuse to apply I'm not saying invalidate, because refused to apply the term provision in order to completely, remedy is again the wrong word, but in order for that statute to be able to be applied in a constitutional way.
Well, Your Honor, that question of remedy was just not before the court. I think what the government's missing is that the entire premise of the Free Enterprise Fund decision.
What do you mean it wasn't before the court wasn't briefed?
All parties, including the United States, understood the term provision, which is just like the one here, to prohibit at-will removal.
Your thought is that the court and Free Enterprise Fund saw a constitutional problem, and rather than rendering the regime constitutional, they left it unconstitutional?
That's right. That's exactly what I'm saying. I'm saying that if the government was right, they should have just said Parsons 130 years ago decided this. The SEC members can be removed at will.
Let me ask one more question, because I apologize to my colleagues for going on at length here, but I'm going to read some quotes from recent cases, a lot more recent than the cases that I think somewhat dominate your brief. And they speak sometimes in dicta, speak specifically to the question of whether we read a statute that has a term provision to silently limit the president's removal power. Collins says we generally presume that the president holds the power to remove at will executive officers, and that a statute must contain plain language to take that away. Sela said the removal provisions were severable from the other provisions, including the term of service provision. Collins did the same thing, as we were just discussing. Justice Kavanaugh, dissenting en banc in a case that the Supreme Court then went the other way on, said, quote, term of office provisions do not prevent the president from removing at will a director at any time during the director's tenure. So assume none of that is binding, none of that is holding, it's all dicta. Is there a way for you to win this case, and for those judges, I think we covered Justice Alito and Chief Justice Roberts twice and Justice Kavanaugh, is there a way for you to win without them being wrong?
Yes, Your Honor. This statutory question was not before the court in those cases. All of those cases involved constitutional issues not presented here. Judge Kavanaugh's dissent, for example, specifically reserves this question and mentions Parsons, but this court in Swan, both the majority and Judge Silberman explained Swan as relevant to core executive officials. That's just not the case here. So that's why those cases are different than this one. And again, if you go back to Free Enterprise Fund, the Supreme Court issued a constitutional holding premised on our understanding being correct. And so this court, other than Swan, has made the same assumption. FEC versus NRA in 1993 assumed that FEC commissioners protected by equivalent term provision are not removable at will. This court in Coloris, quoting Reagan, which was just a couple of years after Parsons, where the term of office is for a fixed period, the appointing power cannot remove at pleasure. And your Honor's question sort of suggests a plain statement rule, but Wiener
doesn't, even if we were to accept that those statements were binding or an accurate description of the law, wouldn't it still depend on whether they were employees versus officers? I mean, why would we presume that any such tenure of protection would apply to mere employees?
Your Honor, because I think I don't think there's any case suggesting that employees can't be protected by term provisions. And so can
you direct me to a statute where that is the case?
I think the Civil Rights Commission at issue in Wilson, this court's decision in Wilson, is similar to this agency. It primarily gave advice. The court held that staggered terms ran with the calendar and emphasized the independent advice-giving function of the agency. So I think it's plausible, at least, that those commissioners would also be considered employees, and they were also protected by fixed staggered terms, just like the council members here.
On what basis do you say he was an employee? He had one of the private citizen slots on the council. He had not paid. On what basis are you asserting that he's an employee for these purposes?
Well, the two questions about inferior officer are under the appointments clause, which again, we don't think is particularly relevant here, but the individual has to have a continuing office, which we say he does because he has a fixed term, and he has to exercise significant authority. That's the test the Supreme Court gave in Lewis.
Yeah, and a single individual on a council that does purely advisory functions within the executive branch, what significant authority does a single private citizen on this council exercise?
I don't think he does, Your Honor. That's why I think he's an employee.
An employee of the government?
No,
No, I know. I mean, there are statutes that define what it means to be an employee of the United States government. And so what definition of employee of the United States government does a private citizen on this council meet? There may be a statutory answer I'm not aware of. I'm not aware, because there are employees who are on this council.
Well, Your Honor, all I mean to say is he's not an inferior officer.
He's not a principal officer. He's not an inferior officer. No, but you were being asked, you said he's an employee of the government. Talking about the ability. The question here is, impose limitations on the removal of private citizens on a purely advisory entity.
Well, he has an appointment by the president. It's in the record. It's signed. You know, I think it's beyond dispute that he has a government position. There's a Form 50 or whatever.
Well, he has some kind of position, but that's you labeled it employee, and I was just probing that. So you're not sure what his status is.
All I'm saying is I don't think he'd be an inferior officer, but I really don't think it matters what you label him under the appointments clause for him to be protected by the fixed term.
So there's a thing called the President's Council on Physical Fitness, I think, in private citizens, usually, athletes or retired athletes, celebrities get appointed to that council. And I believe those appointments are for a particular term, but let's assume that there's a statute that says that they are appointed for a particular term of years. You think that those private citizens have tenure protection?
Your Honor, I think you'd have to look at the statute both in context and in terms of the history at the time the statute was enacted. I think that if it's structured similar to here, where the advice, all the council can do, all the conference can do here is give advice. And so that's why the chairman, JA 69, said the only reason we have our recommendations have respect is because they're thought to carry expertise and political neutrality. And so if you take that away from the agency, there's nothing left. They can't make agencies adopt their recommendations. They can't make Congress adopt their recommendations. All they have is their expertise and neutrality. And if that goes away, then there's nothing else. So it makes sense that Congress would have said—
Well, there are employees of the federal government who are on this council, and the president can remove them, right, from their jobs, and then that removes them from the council.
That's true, Your Honor. And I think that only supports our point because the statute specifically limits the number of government employees. And Mr. Severino was appointed first as a government member, but later, when his service ended, as a non-governmental member. So I think that only supports the inference that Congress was trying to make there be some independence between the agency and the executive branch.
That seems a little odd. What independence is there between this entity and the executive branch when half of the council is members of the executive branch? And the sole function of this entity is to advise the executive branch on the conduct of executive functions. That doesn't feel separate to me at all.
Your Honor, I don't think the sole function is to solely advise.
Okay, the primary function.
Well, by statute, actually, Your Honor, it's supposed to advise all the branches of government. In the statute, it says—
No, No, it has to give a report to Congress, and it may optionally to provide information other than that report to Congress and the judiciary. That's optional. Its mandate, other than that report to Congress, is to advise the executive branch on the conduct of administrative functions, thus the name.
Your Honor, I respectfully disagree. I don't think.
You think its main function is to advise Congress?
I think its main function is to advise all branches of government with independence and neutrality. JA 46 Note 3, OLC emphasizes.
No, tell me in the statute. Tell me in the statute where it says that. I don't want the OLC. I want to know from the statute.
I believe section 594 is where it says who the agency provides recommendations to. And I'd emphasize that it provides recommendations at its own option, not at the request of the executive branch.
Mm-hmm.
That's the point OLC makes at JA 46 Note 3.
Study the efficiency, adequacy, and fairness of the administrative procedures used by administrative agencies in carrying out administrative programs. That's number one. That sounds pretty executive to me. Make recommendations to administrative agencies, collectively or individually. Sounds pretty administrative. And to the president, still administrative. You can make recommendations to Congress or the courts, but don't have to. Arrange for interchange among administrative agencies. Collect information and statistics from administrative agencies. Enter into arrangements with any administrative agency. Provide assistance in response to requests for improvement of administrative procedure. That's not independent. It's working with them to help improve things.
Well, Your Honor.
Presumably a good calling, but that is not remotely independent in the way as Humphreys or Weiner was.
Your Honor, I disagree. 594 subsection 1, what you just read, it's the exact same duty to give recommendations to Congress and the judiciary as
if you read the whole darn thing, this is all, I mean, if you want to tell me that your view is that this is equally advising Congress, because I read you all the provisions, right? All of that section. I mean, I can read more of it if you want, but it's all about assisting administrative agencies. But if your position depends on us concluding that this entity is equally advising Congress and the judiciary, I will accept that as your position.
Your Honor, I'm not going to say equally, but
no, primarily, what is the function of this entity?
Is to improve regulatory processes.
Okay.
Sometimes that's by providing.
Sometimes. Do you have a sense of how often how often does this entity spend its time advising agencies or the president? What percentage of its time?
I'm not aware of that. All I know is that the statute gives it authority to advise all branches of government. The fact that it's advising agencies, many of which are independent, like the FCC and the FDIC, doesn't change the fact that it's supposed to give independent advice. That's what the legislative history shows, that its advice must be independent because otherwise its recommendations are not respected.
I have another question too, and that is, I really don't understand what this conference is. The conference labels itself an independent agency. You talk about that, but then in your brief, you also describe it as a federal advisory committee. I don't know that it at all fits our case law on what it means to be an authority of the United States within the 5 USC 551 definition of an agency. On the other hand, you've got a head that's appointed by the president, confirmed by the Senate. That doesn't make you an agency necessarily, but it's pretty common for that. Gets the pay, same pay as an independent agency. But the assembly itself is listed as a federal advisory committee act, a federal advisory committee. And so I just don't understand what the council is. Is it an agency or is it as you said in your brief, an advisory committee? Or something else? Maybe there's another option I'm not aware of.
The council in particular.
Yeah.
The record reflects that it acts like a board of directors over the agency. I think the government concedes that the conference as a whole is an independent agency that funds the authority.
Well, you said it's an advisory committee, subject to the Advisory Committee Act on page 5 of your brief.
That's right. And it
Are you aware of any advisory committee that is also a 5 USC 551 agency?
I'm not sure, Your Honor.
I don't think there are, but I'm aware of. Maybe the government will know otherwise. So, and we've said that to be an agency, you have to exercise regulatory power. This doesn't have regulatory power. Hand out funds for projects. I don't think they can fund projects. Issue regulations for procedures. I don't think it can do that. It can make recommendations, but it can't issue regulations, and it can't direct executive branch officials. So I'm just trying to figure out why you think it's an agency.
That's how the government has characterized it.
Okay.
I agree with all those characterizations.
So maybe it's not an agency. A Title V definition of agency. Maybe there's some common law definition or something, but
There might be, Your Honor. I think those functions all emphasize, the fact that it doesn't have those functions emphasize why Congress would have thought it needed to be independent.
and then to go with my colleagues, I actually had where I should have started a standing question under Swan. So the theory in Swan is that there's someone below the president who can simply treat, in this instance, treat your client as a member of the council and sort of push off the person who took his place in this instance. So in this case, the council is limited to 10 members. It has 10 members already. And given that he was a private citizen position, I don't know, are you able to identify which council member would have to be set aside so that he could be treated as a council member?
Unfortunately, I'm not. The government might be able to be.
Okay, well, you have to establish standing. So, I mean, is your theory instead that we'll have an 11-member council? That's your relief? No, because the statute is limited to 10.
That's right.
So somebody has to go if he comes in.
That's right.
Who goes?
At the motion to dismiss stage, I don't think we need to prove exactly which
You
person
don't have to establish standing.
We have to establish standing with the requisite proof required at the motion to dismiss stage. And the government concedes in footnote 1 of the red brief that we named as defendants officials who can treat the plaintiff as a member of the council.
Yeah, you didn't address this issue, though, about the numbering, which I don't know was an issue in Swan. It didn't seem to come up there. But here, it seems to me you've got sort of, we're limited by the 10-member cap, and then that this is, like Swan again, a unusual position within a group body where it's sort of hard to identify where to slot your client in. I'm just not sure what to do. So your view is for pleading stage, there's enough, and then there'll have to be proof as to who it was that took the particular private citizen slot that your client had?
That's right, Your Honor. Someone is in my client's spot. And under Swan, it's enough to show that the government, a corollary of Swan is that that person is not supposed to be in the seat. And the individual we as named as defendant, the chairman of the council, has authority to instead treat Mr. Severino as a current council member instead of that.
Okay, thank you very much. We'll give you a couple more minutes on rebuttal.
Honors, Adam Jed for the United States. May it please the court. I'd like to begin, if I may, with a colloquy that my friend had with Judge Walker about what issue the plaintiff has actually put before the court today and how Supreme Court precedent applies to that issue. Because I think my friend struggled with answering the question of whether they're asking for for-cause removal. And I just want to point out, they've really gone out of their way not to ask for for-cause removal. If you look at page 11 of the joint appendix, their complaint, it says that the president has no statutory authority to remove the plaintiff. It doesn't say that there weren't necessary circumstances met. It doesn't say that certain procedures weren't followed. It just says he has no statutory authority. And throughout their opening brief, they say things like the plaintiff has a guaranteed term. His role is inviolable. Page 15 analogizes it to a senator's term. So I think the only issue that they've put before the court today is whether someone with a term of years appointment is categorically unremovable except for by impeachment. And Judge Walker, just to kind of get into, I think, some of the doctrinal questions that you were asking my friend, I'm not aware of any federal case that said that that would be true. But I actually think even if they were arguing for cause removal, they would still have the same problems under existing precedent. Because I think particularly recent Supreme Court decisions have made clear that a term alone is not enough, not even for non-removability, but even for some form of for-cause protection. And of course, because there's nothing in the statute, the court would then have to choose what that form is. And I'd like to just direct the court just to two cases just to make sure that we're all on the same page about this. First, in Collins at page 1782 to 1783, the Supreme Court has a paragraph where they identify a number of agencies where they say the heads of those agencies are removable at will. And if you look through the list of, I think it's roughly 10 agencies that they identify, the vast majority of those have individuals who are appointed to serve a term of years. So in other words, the Supreme Court statement in Collins that those folks are removable at will would be wrong.
Do you happen to have the list? I don't have that page of Collins in front of me.
It's pages 1782 to 1783 in Collins. I think it's the bridge paragraph.
I'm just wondering like what the agencies are that were.
I don't have the list of agencies. I apologize. What I can tell you, sort of agency specific, then I think concerns the severability analysis at issue.
Before you get there, you. Thank you very much. And now, please, if you would, Mr. Jed, tell me again where this list is.
Carryover.
I believe it's the bridge paragraph.
Yeah, carryover, bottom of 82.
Okay. Peace Corps, Defense Nuclear Facilities Safety Board, CFTC, Farm Credit Administration, National Credit Union Administration, Railroad Retirement Board. So you think that all of those are removable at will?
The Supreme Court said they're removable at will.
What's the position of the United States?
Obviously, I don't want to.
This was dicta, so I think so.
I don't on the fly want to start opining on the removability provisions of various agencies. All that I'm saying is, to the extent that the Supreme Court went out of its way to sort of point to a list of agencies.
And I understand that I would be cautious to just on the fly making representations on behalf of the United States government. But your argument, your theory of the statute here has implications that can't have been missed by the Department of Justice as it was preparing for this case. And I would think that your theory of this statute, where you are removable at will, even if there's a term in the statute for the length of service, I would think that that theory would likely sweep in the agencies that you've already mentioned. And also, I'm going to list 6 more: the SEC, the FCC, the FEC, the FDIC, the ITC, and the EEOC. Now, I could have my facts wrong on a couple of those, and maybe they have express for-cause removal protection provisions in them. But for the sake of this question, assume that they don't have an express for-cause removal protection term. They just have a length of years that the commissioners in those agencies serve. Are those commissioners removable at will?
Mr. Walker, I'm certainly not in a position to tick sort of agency by agency through the U.S. Code, but maybe I can answer your question in the following way, which is a plaintiff, if you were arguing for for-cause removal, which he is not, would nonetheless be basing that solely on the existence of a term and isn't basing it on any of the other features that may arise for some of those various statutes. And I can certainly tell you that Collins, and by the way, the severability analysis in Collins and Celia Law and PCAOB all confirm that having a term of years appointment, at least alone, certainly doesn't confer for-cause removal protection. I think my friend's only response to that in the reply brief is just to say, maybe the Supreme Court didn't realize what was going on in the case, or maybe the issue just didn't dawn on them, and actually it was a mistake. And I should say, one, it was holding of the court. The court was explicitly saying, given this problem, here's how we are going to sever the statute. But 2, I think it would be very strange to suggest the court wasn't aware of it. At least 2 of those 3 decisions, including Justice Kavanaugh.
I'm with you, and I think I was pretty hard on your opposing counsel. I was trying to be fair as well, but about what I saw as an incomplete theory of how to interpret the statute before we even get to any constitution. But now I'm suggesting that I think there's something somewhat incomplete, maybe tactically incomplete, about the government's theory as well, because it can't be that the ACUS has one. We're going to interpret that statute in one way, in a way that means that the president can fire Severino. And we're going to interpret the SEC, the FCC, and the FEC in different ways. And I just don't understand why the government can't say, it has to have been a predictable question that it would be asked. Why can the government not say that the theory they're applying to Mr. Severino's former agency applies to the SEC, FCC, and FEC in a way that would allow the president to remove those commissioners at will?
Judge Walker, I'm actually not sure if we're disagreeing about what I can say. Mr. Severino, again, if you were asking for cause removal, and he is literally asking for the opposite of that in his complaint and in his opening brief, would at best be saying that a term of years appointment alone is what confers for cause removal. Again, an argument he's not making, but if theoretically he were to make that argument, and I can tell you that a term of years appointment alone does not confer for cause removal. I don't know that I can stand up here and give you a sort of universal theory that would apply to every statute in the U.S. Code. As Your Honor is obviously well aware, there have been some recent developments in Supreme Court doctrine, but developments on issues that aren't really necessary to resolve for the purposes of this case.
Well, can I ask if maybe you're able to commit a bit more, because we're talking here about removal of a private citizen from a collective organization. I'm assuming that there are no private citizens in roles in the agencies listed in the Collins case, are the ones that Judge Walker.
I'm sorry, I actually can't quite hear you. I apologize.
So what seems different is the only issue before us is removal of a private citizen member of a council, which is not. I'm assuming that the folks protected by terms of office in the SEC and the assorted agencies that Judge Walker referenced and that the Collins case references, I mean, that's what they were talking about.
I mean, certainly the folks that Judge Walker was just referencing are government officers and actually believe heads of department for the most part from those examples.
Right. So isn't the only question for us removal power over a private citizen on an entity that has a purely advisory function?
I think that might be right, but I actually probably need to hedge in two different ways in answering that question. The first, just in terms of the formal status of these individuals, I think the OLC opinions about the emoluments clause that we cite do sort of discuss that. I mean, to the extent that they are serving on ACUS, they then do have a kind of government capacity. I
There may be special government employees for ethics purposes, but they're not paid.
They're not paid. That's correct. The chairman is paid. The council members are not. And I think Your Honor's right. I believe they are
just for ethics purposes.
They are SGEs. Obviously, as Your Honor is aware, that doesn't kind of necessarily sort of trigger FACA. Obviously, SGEs are a sort of somewhat sui generis setup. Your Honor is obviously right that most of what ACUS does is advisory. I think we have identified in our brief at least kind of one example where agencies actually need to follow a certain set of guidelines that are set up by ACUS.
Where is that?
I believe there's a statute that when HHS engages in certain kinds of arbitration, it needs to follow those both existing and future guidelines that were established by ACUS. It's kind of cited at the very bottom of the paragraph in our brief where we discuss ACUS's functions. Certainly the primary function that ACUS serves is advisory. There's no question.
Is that in the HHS statute or is that in the ACUS statute?
I'm actually not. It's not in the original ACUS statute as we detail number of statutes that were created after ACUS is kind of assigned additional functions to ACUS. So I'm not sure if the statute I'm referring to, I believe it's entitled 25, if it's an HHS specific statute, or there are various statutes related to arbitration that have in turn incorporated some ACUS requirements.
Are those guidelines issued by the council or by the conference as a whole? The
I suspect it's by the conference as a whole, but I'm not certain.
Am I right that Severino, when he was on council, has to have been one of these four things: a principal officer, an inferior officer, a federal employee, or not in the government?
I'm not aware of a case that sort of said that would cover the universe. It seems plausible that it would, but as I think, for example, some of the colloquies with Judge Wilkins brought up, there are a lot of these just kind of sui generis entities where it's a little unclear sort of what these folks are. Obviously sort of for constitutional purposes or appointments clause purposes, once you get outside of officer or inferior officer, it doesn't particularly matter for the most part designations like employee.
So do you think that he's one of those four, or some option 5?
And, you know, I just don't want to take a position on that. You know, as I said, he's an SG. It's a kind of somewhat sui generis.
It seems important, though, to us. If we're going to try to figure out whether he's removable at will or not, it seems very relevant to know what he is.
Well, you know, the plaintiff hasn't made any argument that turns on whether he's an employee, inferior officer, principal officer, or whatnot. In fact, he hasn't made, again, any argument about why there would be for-cause removal at all. So to the extent that the court is looking for a kind of minimal way to decide the case, it doesn't need to go any further than just to say he is not non.
Is it in the record, or I guess with the motion dismissed stage, not much of record? Is it in the public record? Why he was fired?
Not that I'm aware of.
And your position is that we can't know for sure which of those 4 or 5 categories he is. What about the conference itself? Is it in the executive branch?
The conference is in the executive branch. Yeah, we cite a relevant regulation.
I'm wondering how often this happens. So I'm going to describe a group of people and then ask you a question about it.
Great.
Appointed by the previous president to a position with a statutorily fixed term under a statute that's silent on whether the president can remove the appointee. You know how many of those people this president has fired at will without cause?
I don't know the answer to that question.
You know some, right? Because some of them are cited in your brief.
Well, if you're referring to this president, obviously I know about the plaintiff in this case. There are, I believe, 2 parallel cases that are presenting the same issue and are currently being held.
And which ones are those?
I'm sorry?
Which ones are those?
One of them was brought by Sean Spicer, who I believe was put on the Board of Overseers.
Do you know if there's an instance of, I'm sorry, what was the other one? I didn't mean.
I actually don't recall.
Okay, that's okay.
Apologies.
Do you know how many times, if at all, someone has been fired at will in the face of a for-cause removal protection?
I do not know the answer to that question.
Just in the past few years.
I just don't know the answer to the question. I mean, again, the plaintiffs aren't even arguing that we have a for-cause removal protection here, and I don't know sort of historically how often that has occurred.
Let me get to the second part of the Severino brief. And that is, he argues that if we interpret the statute his way, the statute is constitutional. And it seems to me there's 2 ways that you could win this case. First, on the statutory question, and second, on the constitutional question. Now, for the sake of this question, assume you lose on the statutory question. Assume we decide the statute prohibited the president from firing Severino. Do you want us to move to the second question and say this removal protection is unconstitutional, so Severino still loses?
So I think I need to push back on the premise of the question a little bit, which is, I think if you look at the way that the Supreme Court has approached the statutory issue, it is obviously colored by background constitutional considerations. Myers, discussing Parsons, makes clear that it was both statutory and constitutional. So I think it's a little bit hard to kind of tease the issues apart quite as cleanly as the plaintiff's trying to in this case.
I appreciate that, and I do think this case raises some hard questions about when constitutional avoidance has so informed the interpretation of similar statutes in the past. How much of that avoidance do we just import, kind of copy and paste style into this, or how much do we have to do ourselves kind of fresh? But that's not my question. My question's a hypothetical. I don't want to sound like we heard a lot of this yesterday's Supreme Court argument, but it's just a hypothetical. I know you might not like the hypothetical, but in this hypothetical where we say the statute prohibits the president from firing Severino at will, do you want to win by us then saying that statute is unconstitutional?
Judge Walker, I think if the court were to do that at that point, then I might want to remand so that we can figure out kind of how that parses out, in all candor.
A remand for what? What would the benefit of the remand?
Well, I understand the district court to have said that this is governed by Supreme Court precedent and that we win on the statute. if this court were to say it's not governed by Supreme Court precedent and you lose on the statute.
And sometimes we remand on questions the district court has not addressed, but quite frequently for a question of law, we don't.
Sometimes they do. Judge Walker, the reason that I'm kind of struggling to answer the hypothetical is the kind of premise that I was given before. I think when the Supreme Court has approached these statutory questions, it's not just that they're engaging in kind of constitutional avoidance, as Your Honor suggested, but rather it seems that kind of background constitutional principles have colored the way that these statutes are understood. And I think Parsons is saying that. And if you actually look at some of the historical examples that
I'm so with you on that. You had me at hello on how profoundly statutory interpretation questions in the past have been colored by this constitutional issue. But on occasion, Humphrey's executor, Weiner, Morrison, the courts have said the best interpretation of the statute is that the president cannot fire the person at will. And it seems like this is a pure question of law. There's no need for any fact finding at the district court. It seems like the United States would say, we think in that case the statute would be unconstitutional, or we don't.
Judge Walker, obviously figuring out kind of how to approach a constitutional question where on the one hand a statute would be rendered unconstitutional, on the other hand it sort of implicates, presidential removal authorities, and particularly doing that in light of some of the very recent Supreme Court cases kind of shedding light on Humphrey's executor and Myers. It's just not something that I would want to take a position on my feet right now.
Is that a reason for supplemental briefing?
If the court were interested in supplemental briefing on that question, on the question of if the plaintiffs had made an argument for for-cause removal, which they haven't, and if the statute meant that there was some either for-cause or for that matter non-removability protection, then yes, potentially we could do supplemental briefing. And by the way, just to make sure that I am understanding Your Honor's question, because I want to make sure I haven't misunderstood, I think if the plaintiff were rendered entirely non-removable, which really is the only argument that they're making, I think that plainly would be, at least raise a constitutional question and very likely be unconstitutional. But if we're talking about the possibility that it's for-cause removal, again, an argument that they haven't made, the court wanted an answer to that, then yes, I think we would want supplemental briefing.
I have one more question, and it's a pretty friendly question. How do you think we should do constitutional avoidance? Not even necessarily we, but just courts in general. Because I can imagine one version that says, you interpret a statute a certain way because you want to avoid the slim possibility that the Constitution might prohibit the alternative interpretation. Well, it has to be more than slim possibility. It has to be probability. Well, it has to be more. It has to be almost certainly unconstitutional. It has to be definitely unconstitutional. Where are you on that spectrum?
Judge Walker, obviously this court and the Supreme Court have probably varied at least a little bit. And
it's another understatement.
The strength of that principle, I don't think it's something quite as clear as, like the rule of lenity where you would need grievous ambiguity or something to that effect. But I actually think in this case, even if the court were interested in applying some form of constitutional avoidance, it'd actually be a lot easier. Here, what we're dealing with would be not just kind of a constitutional question generally, but one with respect to limiting the president's powers. There, we have a sort of separate line of Supreme Court cases that we cite, as well as this court's case in Armstrong, which basically says Congress needs to be quite clear. So I don't know that the court would need to wade into kind of broader, interesting statutory interpretation questions of the concept of constitutional avoidance.
Thanks for your patience with me.
Can I just clarify that answer? And that is, do you believe there's any role, does constitutional avoidance play any role in the disposition of the statutory construction argument presented by plaintiff in this case?
No, Judge Millett, or at least it certainly does not have to. We point out that if you agreed with a number of their statutory arguments, constitutional avoidance might start to factor in. But no, it does not. And I think the answer is...
So you don't think there's any constitutional question implicated by a holding that a term provision forbids anything, forbids dismissal at will by a president?
Oh, I'm sorry. Maybe I misunderstood the question. If a holding which said that a term provision in and of itself gives some kind of for-cause removal would obviously
at least if, or maybe not even that, right, depending on their theory.
Would obviously raise some constitutional questions. And I think in response to that, I was sort of saying to Judge Walker, I'm not sure that I'm prepared to take a definitive position on that.
But
I'm not asking for a definitive decision, but do you think it's a substantial constitutional question?
I think
constitutional avoidance.
there would certainly be a real constitutional.
Okay,
That's right. And I should point out, Judge Millett, by the way, I mean, to the extent that my friend's statutory argument depends on this idea, that every time you see an appointment for a term of years, you actually have no idea what it means, that it's kind of varying based on whether it be constitutional avoidance, or I think as the way that he's constructed really just sort of as applied on constitutionality. And I would just direct the court to what Cilio Law said in the face of a pretty similar argument about what to do with their an actual statutory for-cause removal provision. And it said, look, we're not going to start interpreting this thing to mean different things or be unconstitutional in some places or not others. It's got a meaning. We have to go with that meaning. And here, I mean, certainly by 1966, when this statute was passed, the well-established meaning of the term of years provision was that it was a limit on the length of the term, but it was not a guarantee that the office holder continue to hold the office until he's impeached.
Do you know how many people are on the council today?
I'm not certain of that.
If it were less than 10, would that solve the problem of where to put Severino if he were, we rule in his favor?
I mean, we have not disputed standing in the Court of Appeals. Our understanding is the logic of Swan. It's a somewhat unusual opinion, but our understanding is the logic of Swan would apply. Obviously, if the court were interested in more on that, we could also submit supplemental briefing on that question.
If there were 10, this is not just your understanding of how the conference works. Like, on a court, like there's a spot, and when that spot comes open, there's a person who used to have that spot, and then there's a successor to that person. Does it work that way on the council? So say there were 10, would it be easy or hard to identify who is Severino's successor?
In all candor, I'm actually not 100% certain that as a statutory matter, that's even true on a court. That may just be kind of how folks tend to talk about it. And I'm not sure exactly how that would work. I mean, again, I guess to kind of engage more directly with Judge Millett's question, if ultimately the court held that Mr. Severino needed to be treated as a member of the council, presumably there would end up being some form of equitable order. And then the question would be, kind of how is that equitable order complied with? And Judge Millett, I should point out that I think in the Swan decision, when there was some discussion of kind of how possible the remedy would be, the court did also kind of shrug its shoulders a little bit and say, well, at least if we could get him something, then that would be partial redress. So I'm not certain that he would necessarily need an official council seat, but the question of kind of whose seat he gets, none of that, obviously has been briefed, and that would be something that would just happen at the remedy stage, complying with whatever sort of order were ultimately issued.
Well, just for standing purposes, I'm relying only on their website, which for whatever that's worth, it's a government website, but you tell me whether it's updated. It lists 10 members and a chair, so 11 members actually, including the chair. And so there doesn't appear to be a vacancy unless the website is not updated. So if we assume that it's full and the statute limits it, do you think that he still has standing under a Swan theory because we can't identify sort of because Swan not only gave authority but pushed someone else out. And I don't know how we would do that in this case. Is that something, what does Swan require at the motion to dismiss stage?
I mean, obviously the issue in Swan was just redress. Look, is it possible to give a person their job back? You can't issue an equitable order to the president. And this court in Swan said, well, look, the plaintiff in Swan could theoretically get some form of redress, obviously at the motion to dismiss stage.
No, he could be treated as a member there, treated as having the position at issue there. And the person who took his seat, I forget the name of that person, would no longer have that authority. It was just that it was going to be done by someone lower than the president. It wasn't just that, we'll give you an office with a name plaque and a phone and a chair. It was that he was actually going to take this position. And so are you saying in this case, I just want to understand what your standing theory is in this case. Maybe y'all don't like Swan, but you haven't challenged it here. So what is the standing theory here if there isn't, as far as anyone can tell, a way to put him in because it's already full and it's statutorily limited to 10 people?
And for purposes of standing, all that would have to happen would be theoretically possible at the motion to dismiss stage for some lower level person, presumably the chair,
to be able to provide some benefit to the plaintiff. Now, potentially that benefit could be an office and a chair, as Your Honor suggested. I mean, that itself would still be some benefit, but I'm not.
Wait, so the motion to dismiss, we don't even have to, we have to go, maybe something could happen? That's enough for jurisdiction?
Well, it's not maybe something, it's that something can happen. And whether the something.
Are you assuring me that something can happen?
We have not contested that something could happen. If the court were concerned about whether the plaintiff could be given, if it's an office or a chair, or be given a position.
I think he wants to be on the council. I mean, I can ask him, his client, his attorney can tell me. I thought the relief he wanted was to have his position on the council, not to be, the paper boy for the conference.
Well, again, I don't necessarily want to embrace every broadest statement in Swan, but we're bound by Swan, and Swan does actually suggest that kind of any benefit would nonetheless redress an injury. But Judge Millett, I'm not trying to push back on the premise of your question. I mean, we haven't disputed. I mean, we basically say in our brief, he could be treated as a member of the council. And I understood your questions to Mr. Mills to ask kind of, well, whose seat is he getting? Like, who's getting?
Okay, so your position is he could be treated as a member of the council, even if that made him, I guess, member 12, if you count the chair.
We haven't disputed that. Obviously, I don't know exactly the logistics.
The government's position is that it could happen. He could be treated as a member of the council, even if that would make the council larger than the statute allows.
I don't know whether the consequences seem that council ends up being larger, or he gets some benefits of being a council member, or in effect, someone who's on the council ends up getting treated as if they're not a council member. Those just aren't issues that we've confronted given the way that this was set up. If the court wanted something.
Okay, if his attorney says, he says that what he wants is to be a member of the council, not less.
Obviously, sometimes plaintiffs still have standing, even if they only get less. But if the court wanted supplemental briefing on the effect of Swan on this case, given the particular current facts about the operation of the council, because that's not an issue that has been briefed in any detail, we can submit supplemental briefing.
Thank you very much.
Thank you.
Well, Mr. Mills, what does your client want?
To be a member of the council. And I think since Marbury, it's been settled that if that means the person who is unlawfully substituted for him needs to go, then that's what it means.
Okay, what if we can't figure it out?
I think the government can figure it out. We might.
But if they can't, and my hypothetical is assume they can't, because we just sort of, it's not as though he's taking the position of an agency head. That would be easy. This is a mass of public citizens that are put on here. Say 5 of them are put on at once. If we can't identify one.
It sounded like some relief was still possible, and that's enough.
I know, but so some relief, so less than being a member of the council is sufficient for your client.
It would be sufficient for standing. Yes, Your Honor.
No, for your client's redress, that your client wants it. I don't want a theoretical view of standing. Your client decides what redress they want in asserting standing. You just answered that they wants to be a member of the council, period, full stop. And so would anything less than being a member of the council, period, full stop, provide redress to your client?
Your Honor, I think there's 2 different questions. One would be, what would my client ideally like to be a member of the council? The second is, what minimum is required for standing? And
No, there's one question. There is one question before you, and that is, what would your client accept as redress on this complaint?
To be a member of the council.
Full stop.
That's right.
Okay, then I don't need to hear about theoretical things in other cases where something less could provide standing. That's the only redress that he seeks and the only redress that he wants on his complaint.
That is the redress the complaint seeks. Yes, Your Honor.
And that's the only thing he wants?
Yes, Your Honor.
Okay, all right. Sorry, we'll give you more time since I took over your time.
The government started its presentation here misquoting our complaint. It's that JA-11, the president had no authority to remove at will. It is the government's motion to dismiss and the decision below that never draw this distinction. They're drawing for the first time here between for cause and other removal restrictions. Our only position is that the president lacks authority to remove for no reason at all, which is what happened here. That's all we need to prove to win. The government never provided any explanation of what effect this term would have on their reading. The president could remove it 1 year, 3 years, 5 years, 30 years. The term here would be entirely superfluous under their reading. Last, the government says there's no other features that support reading the term in accord with our reading. I've jotted down at least 10 elements that support our reading. First is the term of office and the history of similar provisions and the grammar. If you look at Humphrey's executor, There's a fixed term, a few other sentences, and then any commissioner can be removed for certain causes. Shortlift says that last clause isn't enough. So what's doing the work of precluding removal? It's the fixed term. It has to be the fixed term because Shortlift said that you can remove them for certain.
I'm going to try one more time on the. Is your theory that he gets for cause removal or he gets something even more protective? And here's why I think it has to be for cause removal that you're saying, even though you don't want to say it out loud. If it's something even more protective than for cause removal, then the only way, I guess, to remove, let's say a serial killer from the council would be either something like impeachment or even worse, no way to remove a serial killer from the council. It's not your position that in whatever the worst case scenario is for someone on this council, it's not your position that they cannot be removed at all, right?
No, Your Honor.
Okay, and so then I guess the thing that's in between for cause removal and that wild extreme is impeachment. In which case, someone on the not even the chair, a council member on the Administrative Conference of the United States has the same tenure protections during their tenure as Article 3 judges. As the president for his 4 years. With so many other people who is that. So your position is that a list of people who it takes impeachment to remove. It would be the president. It would be Article 3 judges, and it would be the council members of the Administrative Conference of the United States.
No, Your Honor, that's not our position. We're saying you don't have to decide. It's the government that wants to force you
What's your
to
theory?
make that
What's
decision.
your theory?
It is that they cannot be removed for no reason.
Okay, thank you. That means they can be removed for cause. Let's clarify.
So the other 9 elements, just to run through them very quickly. The original staggered nature of the term, the government said nothing about that. That it's a multi-member body. That Congress rejected making the agency part of the president's staff, made it an independent agency. That it makes recommendations at its own discretion and directly to other branches of government. That it makes recommendations about changing administrative processes. That it limits the number of government members on the council. That it has historical neutrality. That was considered, this is throughout the legislative history, 19 to 22, vital for its mission to succeed. Its larger conference composition emphasizing balance and expertise and the lack of core executive power. All these factors confirm that the council's independence is central to its mission of providing expert advice no matter who might be in power. Holding otherwise would end the independence of not just this agency, but the SEC, the Federal Reserve Chair, the FDIC, and many other agencies. This court should reverse.
Thank you very much. The case is submitted.
Case number 22-7204, Terri v. Wright, appellant, versus Eugene and Agnes E. Meyer Foundation, and Nicola O. Gorin. Mr. Sells for the appellant, Ms. Davies for the appellate.
Good morning, Your Honors, and may it please the court. My name is Derek Sells, and I'm very proud to be representing Dr. Terri Wright in this matter. Today, I'd like to present 4 issues. Number 1, related to the dismissal of her complaint. That the district court erred when it dismissed plaintiff's complaint and claim for violation of 42 USC section 1981, where the facts in the complaint permitted a reasonable inference that defendant Gorin disparaged her in violation of the party severance agreement because of racial animus. Second, that the district court erred under Federal Rule of Civil Procedure 12b-6 when it dismissed plaintiff's complaint and claim for violation of 42 USC section 1981, where the complaint provided defendants with fair notice of the basis for her section 1981 claim. Third, that the district court erred when it dismissed plaintiff's complaint and claim for breach of contract, where the complaint properly pleaded defendants breached the mutual non-disparagement provision of the party severance agreement, and the district court wrongly held that no such breach occurred, and thereby nullified the terms of the non-disparagement provision of the contract. And then fourth, that the district court erred under Federal Rule of Civil Procedure 12b-6 when it utilized the common interest privilege to dismiss plaintiff's complaint and claim for defamation, where the common interest privilege is defeated by the complaint's allegations of intentional racial discrimination, and that where there was no common interest between defendants and non-party Dr. Mady Henson.
Can I clarify your section 1981 claim, counsel? If you don't prevail that there was actually at least adequately pled a breach of contract, then you can't prevail on the 1981 claim, right? Because you have to interfere with a contract, and if there's no contract, then you can't have the 1981 violation, right? Am I right about that?
No, Your Honor, we respectfully disagree with that. I think under the fair notice provision case law that we've given notice that this is a 1981 violation, regardless of whether or not there was a breach of the severance agreement. Here, we allege that that Dr. Wright was treated differently than white members of the Meyer Foundation, white employees of the Meyer Foundation. And in particular, what we allege is that the statement that was made by defendant Boren to Dr. Henson was one that was equivalent to a situation where a former employer gives a negative review or a negative employment justification or verification or a negative statement about their work to a potential employer. Here, once Dr. Wright was no longer employed by the Meyer Foundation, and because she worked in the philanthropic community, the statement to Rags and president was one that denied her the opportunity to potentially get a job there. And under the case law that we cited, that constitutes a 1981 violation.
So assume for the sake of this argument that I just want to drill down on the breach of contract claim because I'm not so certain about that theory of 1981. How was the statement made a breach of contract by the foundation as opposed to an act for which Ms. Gorin individually could be liable?
Right. The contract itself calls for mutual non-disparagement. And as such, the foundation itself was bound not to disparage Dr. Wright. Under the terms of the contract, the obligation was for not only, in our view, not only to tell the officers of the corporation not to disparage, but once those officers were told and then did disparage, that bound the company. If I could use an example, Your Honor. Let's say, for example, the Meyer Foundation had contracted with a vendor to receive services. And as part of that contract, the foundation indicated that upon receiving the services and the invoice for those services, it would direct its bookkeeper to make payment. Okay? The services were rendered. The foundation itself directed its bookkeeper to make payment. But then the bookkeeper didn't make payment. So now the vendor sues the foundation. Says, hey, we didn't get paid. And then the foundation says, well, wait a minute. All we said we do is direct the bookkeeper to make payment. If she pays it or doesn't pay it, that's on her. We're not responsible. Notwithstanding the fact that the foundation got the benefit of those services. And that's what we have here. We have Dr. Wright agreeing not to disparage the foundation. And she lived up to it. She provided her word, she lived up to her word, and gave the foundation non-disparagement. The foundation then directed its officer, presumably Defendant Gorman, not to disparage Dr. Wright. And yet she does. And we say that because of it, the foundation is just as responsible as if the bookkeeper didn't pay the bills. And I'm certain that under this court's precedent, that if the vendor in that scenario that I came up with sues the foundation and says that they owe money for the services that we provided, notwithstanding what their bookkeeper may have done or not done, that this court would say, you owe the money. You got the service, you got them, and you owe the money. Because you cannot render or read a contract that renders it a nullity. And so there has to be some provision by which Dr. Wright can get redressed. And so I hope I've answered your Honor's question. With regard to...
Did you allege a violation of the breach of the duty of good faith and fair dealing? Or you're just alleging a violation of the terms of the non-disparagement provision?
I think it's incorporated. I don't know if we said those terms exactly in our complaint, but under this court's jurisdiction, under this court's case law, under this Columbia case law, read into every single agreement is the requirement of a duty of good faith and fair dealing.
That may be read into contracts, but alleging a breach of contract, people can allege it in two different ways. They can allege a breach of the terms of the contract, or they can allege a breach of the duty of the implied duty of good faith and fair dealing. But they're usually two separate allegations, I think, unless you think is there a case where we've said that alleging a breach necessarily encompasses both?
Well, I don't know. I know we cite cases, Your Honor. We believe that the cases that we cite go to the proposition that when you allege a breach of contract, that gives fair notice that it would be, either a breach of the specific terms of the contract or a breach of the duty of good faith and fair dealing. And so I don't know that necessarily we're required to state which at the pleading stage. And so maybe, as we go further, as discovery is allowed, we'll be able to amend our complaint if that's required. But I don't think at this stage, Your Honor, that is a requirement. We allege a breach, and we set forth why.
Let's suppose that breach of the implied covenant of good faith and fair dealing is a separate theory of liability than breach of the express terms of the contract. Is it your contention that there is no breach of the express terms of the contract, and that it's only a breach of the implied covenant of good faith and fair dealing?
No, I think that there is a breach of the explicit terms of the contract as well. One of the things that the district court did not do is address the term that's in the contract of mutual non-disparagement. Okay, that term is what it is. It's mutual. It goes both ways. It's not one way and not the other. And so in that sense, yes, we allege that there was a breach of the specific terms of the contract when Nikki Gorin disparaged Dr. Wright. So I think, I hope I've answered your question. Yeah.
How long does the promise to direct last? And here's what I'm thinking. I might direct myself to brush my teeth every day for the rest of my life, but I might be good on that for a few days. But then after a while, I slip up and I get out of that habit. Have I reached the order to myself? Let's say the order is brush your teeth, or did I maybe this is actually, I didn't really phrase this the way I wanted to. Do you see what I'm getting at? It's not your fault if you don't.
I think if Your Honor is asking whether or not there's a time limit on how long this particular term of the contract.
That's a much better put.
Would last, I say that the requirement lasts forever. That there is a duty, a mutual duty, not to disparage one another.
Why is that the case rather than, we promise to direct our employees and directors not to disparage Dr. Wright? We will direct them. Today we will direct them to do that. And after today, no promises.
Well, that's not what the terms of the contract say.
Well, it doesn't say forever, and it doesn't say only for a day.
It says mutual. What mutual means, I think, a reasonable fact finder. What mutual means is equal. And so as long as Dr. Wright is bound by the terms of this contract, so is the foundation and its officer. And so if Dr. Wright could be sued on her deathbed at age 99 because she's disparaged the Meyer Foundation or any of the officers of the Meyer Foundation, then likewise the Meyer Foundation should be required to do the same. I see that I'm over my time.
Okay. I think you have any questions right now. We'll give you a couple minutes on rebuttal. How about that?
All right, thank you.
Ms. Davis?
Good morning, Your Honor, and may it please the court. I'd like to address a couple of issues that Mr. Sellers raised in response to some questions posed by the panel. First of all, I agree that the issue here, based on the complaint that was filed, is whether or not there was a breach of the severance contract. The complaint explicitly states that Ms. or Dr. Wright has brought this case because of a breach of the severance contract. Now, Mr. Sellers would like to focus on the title of paragraph 6 of the severance contract that says mutual non-disparagement and completely disregard the substance of paragraph 6 that specifically sets forth the obligations of each of the parties to this severance contract.
It seems like you want to look at those sentences, but ignore the name of the provision, the mutual non-disparagement. So both of you only want to look at part of the provision. What's mutual about non-disparagement under this contract?
Sorry, both parties agreed not to disparage, and the nature of that obligation is spelled out in the substance of paragraph 6.
So the foundation did agree not to disparage.
What the foundation agreed under the paragraph mutual non-disparagement was to direct its officers, directors, and employees with direct knowledge of the revised letter agreement not to make any false, disparaging, or derogatory statements.
That's not the same. That's not the same thing as an agreement not to disparage. Right? I can tell my kids to make their bed. But that does not mean the bed is made. And it would not be, someone else was, if my husband was agreeing to make our bed, it would not be a mutual bed making agreement, because all I would do is agree to tell the kids to make the bed, but do nothing to require that it happens or to enforce it.
The agreement between the parties was how the foundation could perform its obligation not to disparage when you're dealing with several officers, directors, and employees. And to avoid that paragraph being illusory, the foundation committed to that it would direct its officers, directors, and employees not to disparage in order to achieve Dr. Wright's goal of not being disparaged.
So let's suppose the foundation signs this agreement, and then immediately after the agreement, they send a notice out to all their employees and officers, do not disparage Dr. Wright. And then 5 minutes after they send that notice out, they issue a statement from the board of directors and the president and CEO that says, you know, Wright was a terrible employee and she was toxic and we had to fire her, et cetera, et cetera. Have they complied with the contract?
Responding to that hypothetical, because that is not what occurred here, but yes, they would have complied with their obligation under paragraph 6.
And you think that that's a reasonable construction of the contract? Because under DC law, isn't that like our first obligation is to determine what reasonable people in the position of the parties, knowing all the facts and circumstances, would have agreed to? So you think that if we undertook that exercise, that would be a reasonable construction of the contract?
Yes, Your Honor, it would be, especially given the circumstances that Dr. Wright had the opportunity to negotiate the language in the mutual non-disparagement clause. To the extent that there was any ambiguity that Dr. Wright was concerned about, she could have proposed alternate language to the foundation to clarify any ambiguity. She did not. She signed this agreement knowing that the obligation that the foundation committed to was to direct their officers, directors, and employees.
So the person who signed the agreement on behalf of the foundation was a Dr. Horn, right? Because she was president and CEO and she signed it?
At the time, she signed it in her capacity as president and CEO of the foundation.
Then about 30 days after she signed this agreement, she made the statements, right? At least
That
according to.
Correct. That is what is alleged.
And so you don't think that there's a plausible argument there then that at least if anyone on behalf of the foundation shouldn't have been making a statement, it should be the president and CEO and the person who signed the mutual disparagement clause. You don't think that that's a plausible breach of contract theory?
There is no evidence that the foundation didn't perform its obligation to instruct, and that Ms. Gorin didn't, knowing as the signatory to this agreement, didn't instruct herself that she would not disparage and not.
She did or did not? Sorry, I want to make sure I heard. She did or did not instruct herself?
There's no allegation that she did not instruct herself or intentionally disregarded this provision, that she signed it and then went on and made a comment knowing that this obligation that the foundation had taken on existed. There's no allegation in the complaint.
Would the president and CEO be the natural person to send out this notice to employees?
It could go out from the CEO, it could go out from the COO, it could go out from the board chair.
So it's an open factual question whether, if she sent it out, whether she would have sent a copy to herself.
But there's no factual issue that was raised by Dr. Wright in this case that the instructions were not given.
No, but the question is whether Dr. Gorin was instructed not to do it. was the person who sent the notice was him or herself instructed not to speak? Because usually that's not how things work, right? You don't really send it to you don't direct yourself to do something. So isn't that sort of just an open fact question here?
That
If
is
she
an
sent
open,
the notice
that is an open fact issue, but Dr. Wright has not alleged that that obligation was not performed.
no, but obligation. I'm sorry, go ahead.
If they had a basis for believing that the foundation did not perform its obligation, it would have been alleged in the complaint.
Well, no, what I'm trying to understand is that it sounds like the obligation could be performed if Dr. Gorin sent this notice out to all the employees, but didn't include herself as a recipient as opposed to the sender. So she didn't receive this instruction herself. She just sent it to everybody else. And then
but Ms. Gorin
she's out.
would have been aware of this obligation since she signed the agreement.
Oh, but the contract doesn't say who's aware. It says all they have to do is send out the instruction. It doesn't matter whether people are, under your theory, as I take it doesn't matter whether people are aware of it when they nonetheless make a disparaging statement. But the question is whether Ms. Gorin herself, would have been directed not to speak disparagingly. If she wasn't directed, but she's speaking as she is the voice of the foundation, then it seems to me there's a problem with the concept of mutual non-disparagement.
The obligation that the foundation assumed in paragraph 6 would be to direct. It doesn't obligate the foundation to send anything out in writing, but to make officers, directors, and employees aware that they're not to disparage.
So the provision says it's a mutual non-disparagement, and then the first sentence says that Dr. Wright will not make false, disparaging, derogatory statements about the foundation to anyone, except in the course of a governmental investigation or litigation. And then it says likewise, and then it says the foundation will direct people not to make statements. So the fact that it's called mutual non-disparagement and the foundation's obligations are seated with the word likewise, you think that there's no reasonable construction of that language that would mean that court or a fact finder could undertake to find liability when the person on behalf of the foundation signing the statement actually signing the contract, or actually makes a disparaging statement?
Correct, because the obligations under this agreement go to Dr. Wright and to the foundation. They are the parties to this agreement.
Did Dr. Wright promise to refrain from disparaging anyone?
Did Dr. Wright
Promise
not to make any disparaging? Yes, she did.
Who did she promise not to disparage?
She promised not to disparage any person or entity.
Any person in the foundation, and not to disparage the foundation as an entity.
Right. Or any of the releasees.
I am trying to figure out why this language is the language that was used in the contract. One theory is that it's just boilerplate language. It's standard, and this happens all the time. And another theory is that this language was really not very generous to Dr. Wright, and that was part of a bargain for negotiation, where maybe in exchange for some better part of the contract elsewhere, Dr. Wright gave up a disparagement clause with more teeth. And then the third possibility, I can only think of three, but you might be able to think of more. The third possibility is that she just had a really poor attorney. And so let's take that one out of it. Let's say that she had a good attorney for the sake of this hypothetical. Do you know if this language is boilerplate? And if it's not boilerplate, is it reasonable on the record before us to think that she might have gotten something like a larger severance payment in exchange for this not very generous disparagement?
So mutual non-disparagement clauses are difficult to negotiate when you're dealing with large organizations like the foundation, where there are multiple levels and organizations and an inability to police everybody at each level of the organization. And so as part of the negotiating process, sometimes in this case, the employee is willing to negotiate language, what is found in paragraph 6, recognizing that the reality is there might be a low-level person, for example, a front desk person who makes a...
I'm going to interrupt you, Ms. Davis, and if my interruption messes up an answer that you then think is going to be helpful, I'd welcome it. But let me see if maybe I didn't phrase it right. Is this language boilerplate? Do you know if this language is standard?
I don't know if it's boilerplate for the foundation, but I do know that frequently when negotiating employment severance agreements and an employee wants a non-disparagement provision, this is a concession that is made because it's the easiest way for the employer to actually take steps to try and ensure that there is no disparagement by key decision makers.
But you just said in response to my hypothetical that it would be completely consistent with this contract for the board to send out an email to everyone, including themselves, saying, do not disparage Dr. Wright. And then 5 minutes later, the board sending out an email to the world or posting on Twitter to the world that Dr. Wright is terrible and disparaging her, right? Didn't you just answer me that that would be consistent with the contract? Or am I misunderstanding your prior answer?
I think you may have misunderstood my response, or I may have misunderstood the hypothetical, in that the obligation was to direct certain key employees and directors who had knowledge of the severance agreement not to make any false or disparaging comments. So the foundation could send out a directive to that group, that subgroup. Shortly thereafter, if the foundation then sent out some type of communication that disparaged Dr. Wright, I believe that Dr. Wright at that point might have a basis for arguing that there was a misrepresentation in the negotiation of the agreement as to what the intent was here. That going in, that the foundation intended to engage in some type of subterfuge and fool her into signing this agreement and giving up her rights when they did not intend to honor efforts to ensure that she was not disparaged.
How is that any different than a breach of contract claim?
So the difference is that she would have to allege that the foundation did not intend to comply or perform the obligations set forth in paragraph 6, which were intended to avoid disparagement comments, derogatory comments being made about Dr. Wright.
Why wouldn't,
So it would be a different claim than what Dr. Wright has brought.
why wouldn't a claim of breaching the implied duty of good faith and fair dealing not encompass exactly what you just raised, conceded could be raised?
It could encompass that, but that was not alleged in this case. So going back to
BC law does not require an implied duty of good faith and fair dealing to be separately alleged as a cause of action, which is just encompassed within a breach of contract claim. Then at the pleading stage here, she may not have any such facts, but at the pleading stage here, she would have exactly what you said would be sufficient to object to a soon after signing disparagement by the one person who absolutely knew there was a mutual non-disparagement clause.
But for purposes of a motion to dismiss, the foundation and Ms. Gorin did not have notice that Dr. Wright was attempting to bring a claim of breach of good faith and fair dealing.
That's encompassed, as counsel for Ms. Wright said, if that's just encompassed with any contractual obligation, if she alleges a breach of contract, and breaches of contract take two forms, the letter of the contract and the implied duty of good faith and fair dealing. We're talking about local law here, so if district law does not require you to plead as a distinct cause of action, the implied duty of good faith and fair dealing, just to plead a breach of contract, then that would be met here for purposes of 12b6 dismissal.
But Dr. Wright did not plead a general breach of contract claim. Here, there were specific allegations to a breach of the explicit terms of the severance contract. And upon being advised of deficiencies in the pleading of that claim, Dr. Wright did not amend the complaint.
But one of the express terms is mutual non-disparagement.
Correct.
So if she's saying, that's what I think was breached here, whether textually or as a matter of implied duty of good faith and fair dealing, for the exact reasons you just said in response to Judge Wilkins.
But the fact
wouldn't that suffice under, do you have any case where that wouldn't suffice under district law?
I do not have any case, but we're happy to submit supplemental briefing.
Can I ask you a separate question on this common interest question? What evidence is there that Ms. Gorin's statement was intended to advance or protect the interests of WRAG, or that WRAG had a corresponding interest, a similar interest to Dr. Gorin in this situation? What facts and complaint established that their interests were corresponding as opposed to potentially adverse?
So the allegation relates to the fact that Ms. Gorin was the board chair for RAG, the Washington Regional Association of Grant Makers, and that this alleged comment was raised during a conversation between the president, Dr. Henson, and Ms. Gorin, in which Dr. Henson mentioned to Ms. Gorin that there was concerns being raised in the grant making community about the circumstances of Dr. Wright's termination. So that context explains why Ms. Gorin felt necessary to respond to that question and explain why the rumors were not true.
I thought, and correct me if I'm wrong, I thought that the sequence here was that Ms. Gorin first raised, it was just a side conversation, and Ms. Gorin first raised this, I'm feeling all this heat. And then Ms. Henson and Ms. Dr. Henson responded, yeah, there's a lot going around in the community about concerns here about racial discrimination. And so Ms. Gorin initiates it. Dr. Henson responds, just talking about what's going on in the community. And at that point, Ms. Gorin says, oh, well, here's what was going on. Do I have it wrong?
The sequencing is correct. The characterization, I think I disagree with, in that Ms. Gorin mentioned to Dr. Henson, again, the board chair and the president, that she was feeling the pressure. And then Dr. Henson was the one who mentioned the fact that there was discussion in the grant-making community about the circumstances of Dr. Wright's termination from the foundation.
The WRAG is committed to, the funding that it does is to root out discrimination, to expose it, to root it out, to try to prevent it. And Ms. Gorin's statement were to justify Ms. Gorin's actions. And in doing so, used terminology that could be, these are all disputable fact questions, but that could be consistent with stereotypical labeling of discomfort with successful Black women. And so how do we know there's a common interest between Ms. Gorin, who's trying to cover her decision, protect herself from the reaction of those involved in the civil rights community, and those who are dedicated to preventing and rooting out discrimination?
But if we take a look at the amended complaint that was filed in Dr. Henson's action against Reg, we'll see that she says that the statement that was made was merely that there was a negative climate. That was Ms. Gorin's only comment.
Yeah, but this complaint says...
In this complaint, we have the embellishment of that conversation, but the court can take judicial notice of an individual who's not involved in this dispute and was personally involved in that conversation, who said the sole comment was a negative climate.
Are you suggesting we can choose between those two versions of events at this stage?
I believe with respect to the comment that was made, Dr. Henson, who had personal knowledge, as the allegations in this dispute state, Dr. Wright had no personal knowledge of that supposed conversation until the complaint was filed almost a year later.
So you're saying we should resolve that factual dispute against Ms. Wright on the face of the complaint?
On the face of that complaint, yes.
All right. And another thing is, common interest doesn't apply if someone is not acting in good faith. And there are allegations, and I hesitate to reaffirm these are just allegations at this case stage. Nothing's been proven. But there are at least allegations of racially discriminatory atmosphere at the foundation under Ms. Gorin, combined with an allegation of differential treatment of a white person who was discharged for similarly ambiguous reasons, didn't sort of share the vision. And so with those together, why is that not enough to raise at the pleading stage a factual question on good faith for purposes of the common interest?
That is not sufficient because those supposed events are not closely related to the time when this alleged conversation took place.
It's a month. It was like 30 days.
We also have the fact, going back to what I stated earlier about the relationship between Ms. Gorin and Dr. Henson, and the fact that, as noted, the RAG is in the business of weeding out discrimination, that this conversation would not have occurred in the context of where there would be any type of racial animus.
And so we also have, if we're going to look at that other complaint, Ms. Henson accusing Ms. Gorin of leading to another racially discriminatory discharge. So we've got two allegations of racially discriminatory discharge and allegations in the complaint about a racially discriminatory environment. And that's, in your position, is not enough to plead a question of malice for purposes of the good faith prong of the common interest test.
The allegations raised solely in litigation in this context should not be sufficient.
You have a case that's why these allegations are not sufficient. Wait, I'm going to back up. I assume you will agree that racially discriminatory comments constitute a lack of good faith for purposes of the common interest test. You don't have good faith if you're making your statements out of racial animus.
If there is racial animus that can be inferred from the comments, yes, that's correct.
And so if it can be inferred from the comments, but also there's allegations, and there's allegations of other allegations of racially discriminatory conduct by the speaker, in this case, Ms. Gorin. Again, just allegations, but those allegations are there. That is not enough in your view to raise a question, to sufficiently show at the 12B6 stage, to state a claim that there was not good faith for purposes of the common interest privilege?
Yes, I do not believe those alleged incidents are sufficient for purposes of the Section 1981 claim that is brought with reference to a severance agreement. Those allegations were made in the context of the employment relationship. And in fact, Dr. Wright tries to separate the Meyer Foundation from Ms. Gorin. And so to the extent that the allegation is that the foundation discriminated against her based on her race, I don't believe those allegations are sufficient to find liability under Section 1981.
No, but she has a separate, I'm sorry, I wasn't clear. She has a separate defamation claim, common law defamation.
I apologize. I went back to the 1981 claim.
That's my fault. I wasn't.
I still don't believe that those comments are sufficient or incidents, because they are not tied to Ms. Gorin. They're talking about the foundation and the atmosphere at the foundation.
All right. Any other questions? Thank you. We've kept you up a long time, so thank you. Thank you very much.
Thank
you. Mr. Sells, we'll give you 2 minutes for rebuttal.
Your Honors, I want to start with the common interest privilege. And I think, Your Honor, Judge Millett, you hit on the point that we raised in our brief, that the issue of common interest, if you get past the bad faith in the comment that Nikki Gorin made, Dr. Henson, and you look at the common interest, that is not common. You know, what Nikki Gorin is trying to do is cover her own self, trying to cover her own image. She was the head, the board, the director for the board. She was the head of the board of directors for RAG. At the time that Dr. Henson came into RAG, there had just been a climate survey that had been taken, where it found that the climate of African-American employees in RAG was horrible. You had a African-American employee who was required and forced to give up her seat to a white contractor, not an employee, but a white contractor. You had a number of African-American employees at RAG who said that RAG was not a place of racial equity, that there was a segregated work environment. And that's when Dr. Henson took over, okay? And that organization was
Sorry, I think you mean when Dr. Gorin took over.
No. Dr. Henson. She took over RAG as the CEO. not the board of directors, but the CEO. She took over. That was the climate at Rand. It was horrible. She was brought in to bring racial equity.
Well, I'm talking about the climate at the foundation, which is what your complaint talks about. And it says, under Defendant Gorin's leadership, and then details the.
I'm looking at the hints that Dr.
Well, I want to talk about your complaint.
All right, no, I get it.
Right.
What I'm suggesting is that the motivation from Nikki Gorin to make those comments was not in Rag's best interest. It was in Nikki Gorin's best interest. So the idea that the two had a common interest is just from this record, you cannot find it. It's not there. And that's the only point I was making. So I went back to when Dr. Henson took over Rag, it was in a very bad place. It was a very discriminatory place. Just like when Dr. Wright obtained her position at the Meyer Foundation. There had been, right before Dr. Wright was brought in, there had been a climate survey at the Meyer Foundation that showed that African-American employees at the Meyer Foundation found that it was a toxic working environment for African-Americans.
Did your statement right there just violate Dr. Wright's obligation under the mutual non-disparagement paragraph? Or is
it's in our complaint. It's in our complaint.
Does your complaint violate the agreement?
No, because it's in the complaint. So any statement in a complaint is permitted. I mean, if you're involved in litigation pursuant to the agreement, you're allowed to truthfully testify, truthfully state what the allegations are. So it does not violate the terms of the agreement.
If it were outside the context of a complaint, would what you just said have violated the mutual non-disparagement?
Yeah, it would, yes. But because this is in litigation over...
it overrides the...
Yeah, I mean, you're allowed to testify.
Well, there's an exception for any litigation in the non-disparagement clause.
Yeah.
Whether this kind or others.
Right, and so the idea of Nikki Gorin making these statements as it being in the common interest is just simply not, you can't get that on these facts. And at a minimum, it raises a question of fact as to what is the common interest here. So I just wanted to make that.
Who do the releasees refer to in the mutual non-disparagement paragraph? It's 827 of the appendix. And it says, you agree that you will not make any disparaging statements regarding the foundation or any of the other releasees. And it's just a total, I don't know the answer.
I think what that refers to are the employees of the Meyer Foundation, directors, which would include everybody who works for the foundation.
So JA-26 says its respective predecessors, successors, affiliates, subsidiaries, parent companies and assigns, and all of their respective past and present directors, officers, partners, members, stockholders, plan administration, fiduciaries, insurers, agents, attorneys, and employees.
That covers a wide swath. Now, in terms of, I think, Your Honor.
You're going to need to wrap up here for us.
Okay. The last point is to the extent that the agreement, the mutual non-disparagement language is creates an imbalance in the or like I'm not thinking the right term right now, but if there's ambiguity in the language of the contract, it must be construed against the draft. In this case, the drafter was Nikki Gorin and the foundation. And we believe that as a result, again, as you look at the breach of contract, then you have to look at any ambiguity has to be looked at in favor of the non-draft.
Thank you very much. The case is submitted.